Hello everyone and welcome to Uncivil Law. For today's case, we have the case of Joseph Patrick Cuvilliaux versus the city of Vallejo. In this case, Mr. Cuvilliaux wanted to protest Six Flags, and he wanted to do so using a bullhorn. The city in question had an ordinance dealing with getting prior approval for such things, but he is objecting to the application as it applies to him. So we're going to learn a little bit about what the state can and cannot do when it comes to time, place, manner restrictions, and the use of amplified sound equipment as part of an ongoing protest. So let's get started with this case. The city of Vallejo requires individuals to obtain permits before they use sound amplifying devices within the city. Joseph Cuvilliaux seeks to use a bullhorn so he can amplify his voice during a weekend protest of alleged animal mistreatment at Six Flags Discovery Park in Vallejo. Concerned that the city would enforce the permit requirement against him, Cuvilliaux files this action, contending the requirement violates the First Amendment. The district court denied it, but we reversed and remand. So let's learn a little bit more about the factual underpinnings relating to this particular protest. Cuvilliaux protests abuse and mistreatment of animals by circuses and other entertainment entities. For over a decade, Cuvilliaux has called attention to the treatment of animals kept in captivity and used in attractions at Six Flags. Between 2006 and 2014, Cuvilliaux regularly demonstrated at Six Flags, displaying signs and video footage of animal mistreatment, as well as distributing information to patrons as they enter the park. In May 2014, however, Park Management Corporation, who owns Six Flags, filed a lawsuit to enjoin demonstrators from protesting on its property and eventually secured a permanent injunction to that effect. Since May 2014, Cuvilliaux and his fellow protesters have moved their demonstration to the public sidewalk along Fairground Drive, which borders Six Flags. And fair enough as far as that goes. Six Flags, like every other private entity, has the right to control what it does with its own property. So to the extent that these protesters were protesting on Six Flags property, whether it's their parking lot or otherwise, then, Six Flags has a right to say, well, get off our property. And so they got an injunction for exactly that, because they were violating their private property rights. But of course, people have a right to protest, so they moved to the public sidewalk. So far, so good. Let's carry on. Because both the park entrance and the parking lot are on private property and set back from the nearest public sidewalk, Cuvilliaux and his fellow advocates could no longer physically approach patrons to distribute information and discuss the treatment of animals at Six Flags. To overcome the deafening sound of roller coasters and other park attractions from the sidewalk, Cuvilliaux began using a bullhorn to amplify his voice and increase the chances that patrons could hear his message from inside their cars. Cuvilliaux tried to comply with permit and other requirements. He did not apply for a permit at the July 4th protest to avoid putting Six Flags and the city on notice of the demonstration. He did apply for a permit for a demonstration that occurred a few days later, but he never received a reply from the police department. Because he feared being arrested, Cuvilliaux did not use a bullhorn at either demonstration. Cuvilliaux conducted his own legal research over subsequent months and concluded that the permitting requirement in particular was an unconstitutional prior restraint on speech. In September 2015, he emailed his findings to Claudia Quintia, the city attorney of Vallejo, and informed her that he would no longer comply with the permit requirements. So he did his own research, and he emailed the city's attorney, the representative of the city, and said, this is unconstitutional, I'm not going to do this anymore. Okay, fair enough. Let's see what happened next. Initially, Cuvilliaux's bullhorn use went unchallenged, but as a demonstration in October 2015, a City of Vallejo police officer approached Cuvilliaux and informed him he could not use his bullhorn without a permit. Cuvilliaux asked if he would be arrested for continuing to use the bullhorn, and the officer told him he would confiscate the bullhorn as evidence of a crime. Following this warning, Cuvilliaux did not use his bullhorn any further demonstrations at Six Flags. In October 2016, Cuvilliaux filed this action under 42 U.S.C. 1983, alleging violations of the First Amendment. In his complaint and motion for a preliminary injunction, Cuvilliaux argued the permit requirement burdened his state and federal constitutional rights to use the bullhorn. Even after the city amended the chapter, it retained the permit requirement. So now the court has to discuss what the law is that applies to these kind of permit requirements, both in general and in this particular situation. Is this a time, place, manner restriction, or is it something more? And does this standard meet the judicial scrutiny level that is applicable to this kind of speech restriction? So the court's going to get into the law that applies, so let's get started with this. The United States Constitution and California Constitution protects bullhorns and other sound amplifying devices as indispensable instruments of public speech. In a crowded park or bustling intersection where single voice is easily drowned out, volume enables speech. A restriction on volume, then, can effectively function as a restriction on the speech itself. The right of free speech necessarily embodies the means used for its dissemination because the right is worthless in the absence of a meaningful method of expression. With regard to prior restraint, both the California Constitution Liberty of Speech Clause and the First Amendment recognize that a permit requirement is a prior restraint on speech and therefore bears a heavy presumption against constitutionality. So permitting requirements can be constitutional, but because they put a burden, a barrier on free speech, they have to be more narrowly tailored to the exact situation and factual circumstances to pass constitutional scrutiny. So it's not that it's impossible, it just has to be done with particular care to the speech and other interests that you're trying to regulate, and not put more burden than is required. Nonetheless, both the Liberty of Speech Clause in the California Constitution and the First Amendment allow municipalities to promulgate permit systems that place reasonable time, place, and manner restrictions on speech in a public forum. To pass constitutional muster, a permit system must satisfy 4 criteria. First, the permit system must not delegate overly broad licensing discretion to a government official. Second, the system must not be based on the content of the message. Third, the system must be narrowly tailored to serve a significant governmental interest. And finally, the system must leave open ample opportunities for other means of communication. So you see here that when a state or government entity is looking to regulate this kind of speech, there's a multi-factor test to make sure the kind of restrictions they're putting on are fair to all the interests at bar, and in particular is not based on the nature of the speech that has been given, because that would be viewpoint or subject matter based discrimination. This is supposed to be neutral requirements based on needs of the area, not based on the speaker or the message. So that's one of the critical things that you have to look at when you're court analyzing these kinds of cases. Yeah, and SJ0 points out free speech zones, which are particularly problematic in college environments. The colleges tend to put the free speech zones to be very small, and so a lot of them get whacked for this too. But yeah, the free speech zones thing is a problem. It's definitely, yeah. With the general law out of the way, we now have to analyze the specific statute and the specific fact to figure out whether or not it meets the current test as established by the court. On its face, the statute contains many of the features we've identified as burning more speech than necessary. Although the city of Vallejo argues the section furthers its interest in preventing noise that disturbs the peace and creates traffic dangers, the section requires a permit for any use of sound amplifying device at any volume by any person at any location, without any specifications or limitations that may tailor the permit requirement to situations involving the most serious risk to public peace or safety. Hence, the section applies with the same force to an individual and to a rally of 100 people, to the use of a device in an empty parking lot and at the busiest intersection, to the use of a device at a child's weekend birthday party in an already noisy park, and to the use of a device by demonstrators next to a hospital at 2 a.m. and so on, without any limitations that tailor the permit requirement to the circumstances where public peace and traffic safety are actually at risk. The section covers substantially more speech than is necessary to achieve its ends. So we're under an intermediate scrutiny analysis that typically applies to speech restrictions that are content neutral or subject matter neutral, and this would be such a restriction. Time, place, manner restrictions. So they're normally decided under intermediate scrutiny. So you don't need just any reason, you need a substantial reason. And you don't need any motivation, you need one that's tailored to the motivation. So you need one that is not too broad. You need one that is restricted to the need. Now, you don't need as much as you would in strict scrutiny, obviously, but you do need to make sure that it's reasonably tailored to what you're trying to do. And here they're saying, look, you have a statute that on its face says it applies anywhere, any person, any time, any situation, any amount of amplification. It's just too broad. You have a legitimate interest here, and they point out some of the legitimate interests in that paragraph by saying, well, there's a bit of a difference when you're protesting in the middle of a park during the day and right next to a hospital at 2 a.m. We can kind of see that there's a really big interest difference here. So we're not saying you don't have an interest, but you failed to try to differentiate between the two, and you're requiring a permit for all situations, even ones where it doesn't make sense. So there's situations where it does make sense, situations where it doesn't make sense, and you're not trying to discriminate between the two. So that makes the law overbroad in its application, and so does not pass constitutional muster. The statute's broad sweep is more apparent when applied to the facts of this particular case. Cuvillier wishes to use a bullhorn in demonstrations on a public sidewalk next to Six Flags. This is not an area of the city where people come to seek peace and quiet or to avoid distraction. Rather, this is already a noisy area where patrons flock in droves and scream on various thrill rides. Amidst the noise, the sound of one bullhorn likely will not cause additional disturbance to traffic safety or public peace. It is difficult to see how requiring public notice of the bullhorn's use in this area would advance the city's expressed interest in promoting peace or traffic safety, and the city has offered no evidence to the contrary. By disregarding the injury caused by the permit requirement as a prior restraint on speech, and failing to apply our law on the acceptable scope of such a permit requirement, the district court erred in its narrow tailoring analysis. The district court thus abused its discretion in concluding that Cuvillier was unlikely to succeed on the merits of the state constitutional claim. So here the court is pointing out the intermediate scrutiny requires it to be narrowly tailored to the substantial government interest. So it's possible, it's doable, but you have to tailor it to the specific interest. You can ban people, for example, from protesting right outside someone's home. You can ban people from protesting right outside a hospital at 2 a.m. But you can't ban people from, using a bullhorn in a very busy park or at an amusement theme park, in the middle of the day when there's already lots of noise. It doesn't really make sense. So you have to more carefully, narrowly tailor what you're trying to do to your legitimate interests, which there are some, and the court points out some, but you haven't done that here. And as to this guy in particular, it's definitely overbroad. He wants to use a bullhorn to amplify his voice next to an ongoing theme amusement park. If his bullhorn can overcome the din, we'd be surprised. So even then, it's like, why are you doing this? And it doesn't make any sense, so it fails the intermediate scrutiny analysis that this kind of restriction would require. So that is the end of the case of Joseph Patrick Cuvillier versus City of Vallejo. In this case, we will learn that Mr. Cuvillier wanted to protest at Six Flags because he thought that the animals were being mistreated. Six Flags rightly had the right to, and they did indeed kick him off their property, so he could use the parking lots or other facilities of Six Flags. However, even when he was trying to use a public sidewalk, he was not allowed to use any voice amplification equipment, such as a bullhorn, which was necessary based on the environment because of the massive noise from the theme park he was trying to overcome. However, the city's ordinance on this issue did not try to differentiate different areas on different causes, and so was overbroad in its application, particularly as it relates to him. So they're saying that he does have a good cause and is sending it back for the district court for further findings as to injury and redress of this grievance. But it looks like he will be able to use sound amplifying equipment to carry his message in this particular kind of circumstances. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.